Development Bank of the Philippines. V. Commission on Audit, GR number 88435, January 16, 2002. Opponent D. Justice Carpio. Facts. As a condition to obtain a $310 million economic recovery loan, the World Bank required the Philippine government to rehabilitate the DBP. One of the steps required is for the DBP to be fully audited by external independent auditors. Accordingly, the central bank issued CB Circular 1124 providing that, quote, all banks, including government banks, shall be fully audited by external independent auditors. End quote. Commission on Audit Chairman Tafisto Ging Ono interposed no objection on this. DBP hired Joaquin Cananan and Company as its private external auditor. DBP sought Commission on Audit's concurrence to the contract it entered with the private auditor. However, Commission on Audit under the new chairman, Euphemia Domingo, protested the issuance of Circular 1124 saying that it encroaches upon the Commission on Audit's constitutional and statutory power to audit government agencies. Commission on Audit issued a letter decision denying DBP's note request concurrence. Commission on Audit likewise disallowed any payment to the private auditor by DBP. DBP appealed to the Commission on Audit en banc. It denied the appeal. Hence, DBP filed this petition for review on certiorari. Issue 1 of 4, whether or not Commission on Audit has the sole and exclusive power to examine and audit government banks. Held, no. Important to the resolution of this issue is the interpretation of Section 2, Article 9d of the 1987 Constitution. The Commission on Audit argued that the nature of its authority under the first paragraph of Section 2, Article 9d is similar to its sole and exclusive authority under the second paragraph of the same section. The bare language of Section 2, however, shows that the Commission on Audit's power under the first paragraph is not declared exclusive, while its authority under the second paragraph is expressly declared exclusive. This distinction was intended as shown in the deliberations of the Constitutional Commission wherein the framers, 1. recognizes that there are government institutions with private investments in them, which require the presence of private auditing firms, not exclusively, but concurrently. 2. recognizes that there are certain instances where private auditing may be required, like the listing in the stock exchange. 3. recognizes the fact that even government agencies, instrumentalities and subdivisions sometimes borrow money from abroad. Thus, the Commission on Audit's power to examine and audit should and is not exclusive. Note, the authority to define the scope of its audit, promulgate auditing rules and regulations, and disallow unnecessary expenditures is exclusive. Commission on Audit's findings and conclusions prevail over those of private auditors. Its findings and conclusions still bind government agencies and their officials. Issue 2 of 4, is there any statutes prohibiting government banks from hiring private auditors? Held, none, but there is a law that requires government banks to hire private auditors. The Commission on Audit argued that Sections 26, 31 and 32 of PD 1445, also known as the Government Auditing Code of the Philippines, prohibit the hiring of private auditors by government agencies. However, this is inaccurate. Section 26 merely defines the scope and extent of the powers of the Commission on Audit. Nothing in it states that the Commission's power to examine and audit government banks is exclusive. Section 31 merely grants authority to the Commission to hire and deputize private auditors to assist the Commission in the auditing of government agencies. Such private auditors operate under the authority of the Commission on Audit. Nothing in it prohibits the hiring of private auditors by government agencies. Section 32 speaks of studies and services that the Commission on Audit may choose not to render to a government agency. The subject of these contracts is not the audit itself of a government agency. However, CB Circular 1124 requires government banks to hire private auditors. Note: Central Bank has the express constitutional and statutory power to promulgate the said circular. Issue 3 of 4, whether or not the hiring by the DBP of a private auditor is necessary. Held, yes. The hiring of a private auditor was not only necessary based on the government's loan covenant with the World Bank, it was also necessary because it was mandated by Central Bank Circular 1124 under pain of administrative and penal sanctions. Issue 4 of 4, whether or not the fees paid by DBP to the private auditor is reasonable under the current circumstances. Held, yes. An annual private audit fee of about $500,000 added to the interest on a $310 million loan would hardly make the cost of borrowing excessive, extravagant or unconscionable. Besides, the condition imposed by a lender, whose money is at risk, requiring the borrower or its majority-owned subsidiaries to submit to audit by an independent public accountant, is a reasonable and normal business practice. Moreover, in 1986, the private auditor billed the DBP the amount of 487,321 Philippine pesos and 14 centavos, and in 1987, 529,947 Philippine pesos. In comparison, the Commission on Audit billed the DBP an audit fee of 27,015,963 Philippine pesos in 1988. And 15,421,662 Philippine pesos in 1989. Even granting that the Commission's scope of audit services was broader, still it could not be said that the private auditor's fees are excessive, extravagant or unconscionable compared to the Commission's billings. Decision: the petition is granted. The letter decision of the Chairman of the Commission on Audit, and the letter decision promulgated by the Commission on Audit and Bank are set aside. The TRO issued by the court enjoining Commission of Audit from enforcing the said decisions is made permanent.